All right. Well, good morning, everybody. Very big news already. We got some questions from the jury. And as you saw, we got the stream up. So as soon as they go live, of course, with the answers to these questions, we will go live. So instead of just hearing from me, Solomon was available. We just had a conversation about 3 minutes ago saying, hey, the jury's got a question. Are you available? Let's just see if you can go live. I know Solomon's got a lot of stuff that he's busy with, but luckily he was in his office saying he can come live with us and watch some of these questions, some of these answers. So I'm assuming you guys all heard the questions. Here's Solomon himself. Solomon, we spoke about the questions. I'm assuming everybody heard the questions. So let's go through the questions one at a time before the court goes live with the answers. So the first question let's talk about is the question about the clips. The jury wants to know, are the clips evidence and what type of weight they can give the clips from Karen Read?
Certainly not good for the defense. Those clips don't have anything good to say about her. They were only presented by the prosecution. And if you'll remember, they were I think the biggest piece of evidence that the prosecutor pointed to in his closing. Makes you wonder what's going through their heads with those clips and what they actually prove. I certainly don't think that they prove murder, certainly in light of all the other evidence that was introduced at trial, especially those last two expert witnesses for the defense. But it's a very, very dangerous game trying to guess what a jury might be doing when they ask for specific pieces of evidence, as you and I both know. So who knows? Who knows what they intend to do with this or why they're asking?
Right. I agree with you. My knee-jerk reaction from hearing them question about the clips, there's nothing really good about those clips for Karen Read. So the fact that they're asking about what type of weight to give that type of evidence, definitely not great for the defense. However, the next two questions is what really I think is the Karen Read people are going to like. Because let's talk about the first question. The first question was, with respect, or as Robert Leslie likes to say, with regard to the OWI, is the OWI charged for the 12:45 a.m. when she was driving, or is it for the 5 a.m. when she was driving? So I think that's a great question by the jury. So what do you think? You're sitting on the defense table. You've heard the evidence in this case. I mean, I guess you didn't hear all the evidence, but the jury comes back with, well, are we supposed to try to determine whether she was drunk at 12:45 in the morning or 5 o'clock in the morning? What does that tell you? And I'll tell you what it tells me after.
It's actually a very good question by the jury. It's a very fair question. It's funny because sometimes as lawyers, and obviously you and I, though we're not trying this case, we're kind of thinking of this case as lawyers might think of it. And it's funny because we've all seen this happen. Lawyers and judges are constantly trying to make sure that everything is presented to the jury so that they have everything in front of them. And sometimes we get so lost in the weeds that, we kind of miss something which might be glaringly obvious. This is a rather glaringly obvious question because obviously she drove twice. And it's a very fair question by the jury to wonder which driving are we talking about, the midnight driving or the morning driving? Again, I think this is probably not good for the defense in that they're probably leaning towards convicting her of the midnight driving, assuming the judge says, yes, you can convict her of either one, which it's funny. Based on the way the evidence was presented, I don't think they could convict her on the 5 a.m. driving. I just don't, because there's no way of determining what the BAC was when she drove other than, I guess that there was some blood and there were some other things. It's very tricky because you can't connect the drinking, but you can connect the blood. But then there's reasonable doubt because of her medical condition. I think it's a very good question by the jury. I think if the answer is you can consider either one, she's probably looking at a drunk driving conviction here, which if that's all she's looking at, that is a huge win for the defense and a tremendous loss for the prosecution.
And okay, so now let me weigh in on what I'm thinking about the question about the OWI. So with regard to whether it was 12:45 a.m. or 5 a.m., here's my thinking. The clips, obviously, she was talking about her driving herself at 12:45 in the morning, and she said that she felt buzzed. So if she felt that if she was saying herself that she felt buzzed, well, maybe they're trying to figure out, okay, can we use those clips that she's basically acknowledging that she was buzzed at the time and probably shouldn't have been on the road? Okay, that's kind of like an admission. That's an easier avenue to convict her, let's say, on just OWI plain. Now, the 5 o'clock in the morning, there's another question because we know that there was a suggestion that maybe she drank when she was home. when she got home. But anyway, we're going live now. And if she drank when she got home, then 5 o'clock in the morning is not going to help you there because that was after she got home. And then if you used it, okay, well, here we go. We're going to add this. Give me 1 second. We're going live. Here we go.
All right. So I will hear you on the first question, the time of the OUI.
Okay, wait. Before we get to this, I just also want to add the last question that she asked just quickly, just so everyone can get caught up. The last question was, if they find her guilty, I think this, again, I'm not paraphrasing, but if they find her guilty on the lesser included, which is just, for example, they said, for example, 2 to 5, which is just OWI, does that mean that it's a conviction on the entire charge 2? Which would mean to me that they really want to make sure that if they are convicting her on just plain OWI, that's all that it is, and not for involuntary manslaughter as a result of OWI. So that is like music to anyone who's on Karen Reed's side. That is music to their ears. Wouldn't you agree with that?
Yeah, absolutely. That's indicative of what they're thinking. And at this point, based on that question, assuming you're paraphrasing it correctly, I'd be terribly shocked if we have anything other than a guilty verdict on drunk driving and not guilty everything else. Let's see what the judge says.
Okay, so yeah, we're going to get right to the judge, what the judge is saying, but the judge basically gave both sides some time to figure out what they want to answer. So here we go with the live.
Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from whoever's, you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
Mr. Brennan, or whomever from the Commonwealth?
That's a good answer.
And why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment regarding the time.
Do we have the indictments?
No.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
I agree.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember. We can pull that up.
There's no time? I don't expect that there's any time.
All right, so I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
There's a lot of hot mic moments there. There's a lot of people whispering.
Yeah. The risk of trying a case in front of the national audience.
You hear people whispering.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been interviewed substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce.
You're grasping at straws again.
Wait, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. Weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. I suggest that there's some deterioration or further analysis that's different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws, in keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
He's absolutely right on this. Jackson's right. Brennan's not. Let's see what the judge does. I don't think it's going to matter, though. It sounds like the jury has their mind made up.
Yeah, I mean, the way that last question was phrased is like they really want to be very careful that she's not going to be charged, found guilty of charge 2 of murder, involuntary manslaughter, just OWI. That seems like all they want.
That certainly is what it seems like. And of course, they say never guess what a jury's thinking, right? But based on that question, it's kind of impossible not to. It's kind of like if you're in a trial and the jury has a damages question, which of course the way it works is you only get to the damages if you assign fault against the defendant. So if they say, how much money are we allowed to award for this particular injury? And then they come back with a no cause, that would really make everybody's head spin.
Yeah, remember when we got asked for a calculator?
Yes, I do remember that. Every plaintiff's lawyer's dream question. Can we have a calculator? I had a juror one time ask if there's a maximum that they're allowed to award.
Yeah, that's music to your ears. And by the way, everyone who's putting in questions, we're going to try to get to the questions after this session's over. So you can keep putting in questions, but I don't want to stop to take the questions because I think everybody just wants to see what's going to happen, and then we'll talk about it after.
I mean, based on these questions, I'd be pretty surprised if we don't have a verdict pretty quickly. Of course, it's also possible that 10 jurors had this question, so they sent the question out, and there's still one juror, sitting there with his or her arms crossed, saying, "No, I don't care. I don't agree." That's also possible. There's all kinds of possibilities. You never really want to guess. I don't know what in the world happens in a jury room.
Yeah, but I'm telling you, wait till you hear the third question verbatim, because I think you're going to agree with me that sounds very good for Karen Reed.
Unless, of course, there's one juror sitting in the corner. There was actually a judge who told me that the first time he tried a case, it ended up being a mistrial because there was one juror who sat in a corner with her head in her hands and said, "I don't care what anybody says. I'm not doing a verdict."
What I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
I don't have a principled objection to it if the court adds the word "if any."
I understand.
Because I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the third one. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
No.
Your Honor, I appreciate the effort that the court went to amend the verdict slip.
Whoa.
As it relates to count 2, and I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of, no, new verdict slips have been provided that will make it more clear, or something of that nature. As well as a decision of guilty on the OUI charge 002 number 5 is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law.
You see what happens when you have
And then
confusing verdict slip?
there are
Solomon?
suggestions
Yeah.
that we have
Gee, who would have thought?
regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you and put those
Okay,
on the
go
record.
ahead.
With regard to going from the top to the bottom, just under number 1, number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the language, the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right. I think I'm going to leave it because it appears only under the guilty.
It appears only on,
Under the guilty. So go ahead. I'll hear you further.
going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent, if you find the defendant guilty of the lesser offense
Okay.
of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them,
Correct.
which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again,
Hold on one second.
of course.
By the way, if anybody in the chat knows that there was a second amended verdict slip that was provided to the jury, please send it to
Okay.
me. Please email it to me.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following, and there's a typo. It says the
We
parenthetical says
fixed it.
check one of. Okay.
Yes. So we changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict slip.
Right. After the word stop and sign the verdict slip.
Yep.
And then under sub 5, again, the same thing. We just suggested that for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan.
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think that the edits, this proposed instruction explained it.
All right.
I don't have any issue with if you state, if you decide on a lesser included offense, it does not include the earlier offense. I'm not sure of the exact language that can be. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form she's filled it out with the credits would be sufficient for them to follow.
What do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense. It would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out
Brennan.
and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
Yeah, I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should reemphasize that, and we're not asking for it.
All right, so you're waiving it?
We're waiving it.
Okay.
Yes,
All
thank
right,
you.
I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony. All right, thank you. Ron.
Okay, so it looks like they're amending the verdict slip now. And again, I don't know if they amended it before, but it sounds like now she's going to amend it because the jury's confused about it. What a surprise! Anyway,
and it sounds like what they're amending it to is to make it more clear that if you're finding them guilty of a lesser included, you're finding her not guilty of the higher included. That's makes the most sense. Just include it directly in the verdict form. Let the jury know what their verdict is going to be. There's no reason to trick them. This original verdict form was insane. But who can read it? Who could understand it? It took me several times to read it and understand it, and before I really understood what was going on in it.
yeah, and then we brought out some of the problems with it, like if they're hung, with some of the lesser included. Let's get to some questions here. Here we go from Sean Broadwick. Uncivil postulates the lesser included cannot change the time frame, so should be limited to the 12:45 a.m. time frame. So
Not sure what that means.
I'm not sure what it means, but what is clear, and I think what we both agree about, is that if in the indictment it doesn't say a time, well, then the jury can use the evidence and try to figure out what they're talking about, and if they prove their case. So yeah, anytime, at any point, using whatever evidence they want to figure out a verdict or come to a verdict.
Right. I agree.
Rhonda, Iowa girl, I think the clip were about the number of drinks she was talking about having when you add the other questions. Yeah, so some of the clips, okay, so not just, I was talking about the clip when she said that she was buzzed. I don't know if you saw the Salmon, but some of the clips where she was talking about how many drinks she actually had. She said she only had like 3 or 4, and they were very weak drinks anyway. So, talking about using that as evidence. So
I think there's little question that she most likely drove drunk that night. Based on the evidence, it certainly seems that she did. In fact, during one of our other videos, when we were talking about those voicemails that were left, my initial response was, she is a drunk. She's drunk. She's angry. She's hurt. And that's why she's yelling at John. Not, haha, I just killed you, but hurt that he's still in that house, but clearly drunk. She sounded drunk in those clips.
yeah.
Don't get me wrong. If they find her guilty of only drunk driving, that is a tremendous win for the defense. Tremendous.
Absolutely. I mean, no questions. No questions.
Now, that said, Massachusetts is one of the toughest states in the country on drunk driving. I was able to research this a little bit. You could be sentenced up to 2.5 years in prison, but they virtually always get probation. And I think even Judge Cannone would have a hard time doing such a disproportionate sentence, even for Karen Reed. Look, a loss is a loss. So,
Yeah, well, we'll see. I mean, it sounds like that's how the jury's leaning, but we'll see. Next question by, get this name right, Quita G. I think the jury is confused by that ridiculous verdict form.
Yeah.
I am okay. I think everybody agrees about that. I am okay with the OUI only charge. If that's all they find her guilty on, then that's the end of this case. Smart move by the defense, adding that.
Yeah, definitely smart move. Of course, the what if games, assuming they come back with guilty only drunk driving, then the what if games start. And the what if games are, if we wouldn't have asked for the drunk driving charge, would they have just said not guilty all charges? But there's no way to spin this in a way that it's not a massive win for the defense. Again, if the jury does as they're indicating they likely will do and just find her guilty of drunk driving.
And if she's just facing probation, which is what she should be facing, who cares? Let
It's
her.
still conviction. It's not fun. Nobody likes to be convicted, but yeah, going from where she was going, plus the fact that she will be able to sue the bejesus out of a lot of people right now. And by the way, anybody who's watching this, if you called Karen Reed a murderer or a killer on Twitter or on a video, and she's found not guilty, you better lawyer up, because she can come after you for slander, defamation, libel.
All right. Well, there you have it from the civil rights lawyer. By the way, remember we spoke about if she's found guilty of OWI, if that means that she's barred from having a civil rights action. Not talking about the defamation right now. We're talking. I want to ask you about I know we spoke about it a little bit in the last video.
Yeah.
But now that you brought it up, about the defamation lawsuit, were you able to get a little bit of a better understanding about that? Whether if she's found guilty of OWI, and I think you said that she would still have a viable civil rights lawsuit.
Right. I think she would. It becomes a little stickier because there's a conviction for drunk driving, but the two charges are so distantly related. And when you look at the case from a fact specific analysis, I don't see how any federal court would not allow a civil rights claim to go through based on the complete fabrication of evidence and complete fabrication of, or I should say alleged fabrication of evidence and alleged Brady violations, which formed the basis of charging her with murder in the first place. And that's essentially what the civil rights claim would be. As far as an abuse of process claim goes, and I don't know if anybody remembers me mentioning that, I don't think this particular circuit allows an abuse of process claim. But it does allow Fourth Amendment violation and 14th Amendment violation for due process.
Let me just get this, and we'll come back to that original question. Mr. Meathook says, note, jury called her Karen. A good thing, humanized her.
I didn't catch that, but yeah, Mr. Meathook, 100% right.
Yeah, I didn't catch that either, but that's a good pickup, if they're calling her Karen. Let me ask you this, Salman, just to play devil's advocate, because I love to do that. Let's talk about, potential defamation or libel lawsuits. And if somebody on Twitter calls her that, and they argue, well, I had a good faith basis because all the evidence that I saw pointed to her being the one who killed him. So that's why I said it. I had a good faith basis. It was reasonable. And that's why I called her that. And I didn't know that it was false. Defamation, part of it is that that it's false or that it is false. And I believe that it's not false. I believe that it's still true. As we sit here today, I still believe it's true. Okay. What about that?
So say you believe it. When you say something matter-of-factly like that, that is where you get into very dangerous territory. That's why if you ever watch the news, if you ever watch any news outlets and news anchors, they always say the word alleged every single time. Watch any criminal case that's ever been talked about by any news anchor. I can't find a single one. I don't think, as I sit here now, I can't think of a single one where they've ever not said alleged. No matter how obvious it is, even if it's the most obvious case in the world, like somebody gets in a vehicle and plows through people at a parade and everybody knows it and everybody sees it, they still say allegedly did this. You don't say it as a fact. Once you say it as a fact, instead of as an opinion, or say, I think the evidence shows. There are ways to say it where it's not defamatory, but if you say it defamatory and you're negligent in the way that you say it, then you can get sued. You can't call somebody a murderer and then say, oh, well, it was a mistake. I thought she was a murderer. You can't do that.
Well, right.
That's legal trouble.
Right. So I understand the fact versus opinion. I understand that element of the defamation. And I was just wondering about the other part of it, which is that it has to be false. And if you have what you believe is evidence that it's not false, and you can still argue that, you'll still argue that today. You'll say, well, I still believe the jury got it wrong. And at the time, the evidence pointed to this being actually true.
So if somebody called Karen Reed a murderer, and now Karen Reed decides to sue that person for libel and slander, then that person is now going to have to prove to a jury that it was true and that she really is a murderer. Good luck. Good luck. The prosecutor couldn't do it with an unlimited budget and 2 trials. But if you can do it as a keyboard warrior who likes to say nasty things about people, good luck.
Mm-hmm. And I guess the issue about a good faith basis, like I didn't do the research on this, but wondering if there's if you have a good faith basis that your statement is true, and then it turns out to be that it was false. Let's say you have that situation where you think it's true, and from what you know, from what you've seen, it's true. Turns out that it was false. Maybe there's some sort of retraction. Maybe. What about if all these people after the verdict comes out as not guilty, they say, "Oh, okay, we retract everything that we said. We was just opinion. We thought that she was guilty, but really now that the jury has spoken, we retract everything that we said." You think that's going to help them?
Well, okay, retraction minimizes the damages. It doesn't eliminate the lawsuit. And a good faith basis alone typically does not get you out of a defamation lawsuit. You can have good faith all you want, but again, there's got to be more. It's got to be more than that if you're saying it as a fact. Mm-hmm. Sometimes there are certain privileges that apply as well, but it wouldn't apply here. If somebody's just going out on Twitter or going out on TikTok or YouTube and calling somebody a murderer, you can't do that. You and I had a video where you showed me a tweet from some other prosecutor, something or another, prosecutor podcast, and it said something like everybody's favorite murderer. And at the time I said, they got to be careful because if she gets exonerated, she can sue them. Mm-hmm. And I'm guessing she probably will.
All right, well, here's another question from Verdict Statutes by VS. Were you guys able to look at the law's re-verdict slips? If so, what are your opinions about it? I wasn't able to do a lot of research in it, but I did have some people that sent me some research, which did seem to suggest that the law in Massachusetts is, get this, Solomon, that the law in Massachusetts is, and again, I didn't do a deep dive on this, but this is what I've seen a little bit from people sending me stuff, which is why I have such a great community here, that in Massachusetts, if you hang on even a lesser included, like for example, in this case, if they were to hang an OWI, then it's considered hung on the entire charge.
Yeah, I saw that too. And I think that is the law in Massachusetts, and I think that's crazy. But if that's the law, that's the law.
Yep.
The law is an ass. Who said that?
Who said that? Who said that? Quita G.
It's Oliver Twist. It's Charles Dickens.
Oh, this judge really irks me. I'm an attorney, and I don't even understand that jury form. It's confusing. She could have amended it when the defense asked to avoid this. I hope she retires after this.
Quita G, I said the same thing, and it's somewhat embarrassing as a lawyer to say I don't understand this verdict form, but I didn't at first. I had to read it a few times, and I'm still not sure I understood all of it, but I think now at least I know how I would fill it out if I were a juror, especially now that it's been discussed.
Joshua Mundha, shalom to my fellow sons of Abraham. How likely is an appeal win for the OWI? Well, I would think they're not going to appeal an OWI.
I think, of course, they would. If it's a jury conviction, why not? It's an appeal of right. There's no reason not to. How likely is an appeal? Not very likely. Most appeals are extremely unlikely. That's why something I've noticed when a trial judge knows that they're doing something wrong, very often they'll say, well, it's been preserved, because the judge knows that your likelihood of getting something overturned is virtually zero. Our system is made to protect jury verdicts because usually juries get it right.
Mm-hmm. Which is why a lot of people are very nervous. They've been saying how nervous they are about this case. Definitely people on the Karen Reed side. And I told them, I said, look, like we know, most of the time the jury gets it right. So, this is something that we would bet on and win 9 out of 10 times. So, number one, most of the time they get it right. And number two, remember what has to happen in order for her to get a conviction. That means that all 12 people have to get it wrong. So it's one thing if you want all 12 people to get it right and say that she's not guilty, but for all 12 people to get it wrong and not even have one or two people that are reasonable and realize that there's reasonable doubt here, so at the very least, what you should get again is a hung jury, which is why I thought that even though the verdict should be not guilty, I just thought that they may hang because you may have one or two guys that drink the Kool-Aid that some of these Twitter warriors do, and they may just think that she's guilty. So, it's hard to convince two people of anything, let alone 12. But
by the way, I just pulled up, because I was curious about this. I just pulled up the good faith exception in Massachusetts for defamation, and it's kind of what I thought it was, but not as specific as I thought it was. Which is that if you have a qualified privilege, meaning you're talking to the police in good faith, you're talking to an employer in good faith, you're talking to a business associate in good faith, and you say something negative about somebody, like for example, hey, what do you know about this guy? Oh, I would not trust him. He's as far as I know, he stole money from a client. Okay, and I'm saying that in good faith, and I'm saying that to a business associate because I'm saying you shouldn't do business with him. That's the kind of qualified privilege where good faith would protect you. If you just go off on Twitter or TikTok or YouTube or whatever else there is and just blabble about somebody and call somebody a murderer, you're not going to have a good faith privilege there. So, like I said, if you've been out there calling Karen Reed a murderer,
and then the question also, and Salman, as you know, the question also is going to become, okay, well, what type of damages did she suffer as a result? Now, we understand from the Johnny Depp, Amber Heard situation where Johnny Depp actually was not able to get contracts and was, lost a ton of money because of that. But, what would you say the damages are besides to, I don't know, kind of her reputation a little bit in that little world? But is there any monetary damages that they'd be able to point to and say that this caused her a financial loss?
It's always hard to do financial loss, but financial loss is not enough. Reputational harm is sufficient. And anybody being called a murderer all over the internet by thousands or hundreds of thousands or millions of people, and it being shared willy-nilly without really a basis to do that, is certainly reputational harm. There's little question about that. So, how much are the damages? This is going to sound tiresome after a case like this, but I would let a jury decide.
Let a jury decide.
Yeah, just let a jury decide. You can't Google the name Karen Reed without having it come up. Karen Reed is guilty, or Karen Reed is a murderer. That's because of people like whoever the defendant is in this case, who decided to just start calling her a murderer without letting the court system do its job.
Michael Boyle, is she limited purpose public figure in defamation?
That's a good question. No, she's not a public figure. She was thrust into the public by this case. A public figure is somebody who is a professional athlete, an actor, an actress, a politician, somebody who, or, a pundit, somebody who goes out there. You and I, for purposes of this case, would be considered public figures. If somebody says nasty things about us online and says, the Radner brothers are the worst lawyers in the world, we'd have to prove, I guess, actual malice. It's a higher level because we are allowing ourselves to be out in the public like this. We're allowing ourselves to be public figures, so to speak, to your audience. But to somebody who's just, to somebody who gets arrested and allegedly framed, no, that's not considered a public figure.
Yeah. Love on T, thank you very much for that super sticker. We got another question here. Let's see. We got G-Force Lexus in the sky. It could have shot off into space. As an engineer, are the brothers aware that Massachusetts has a secret closed-door court system for the politically connected? Just Google Massachusetts secret court. It's the first time I'm hearing of that.
Inside the secret courts of Massachusetts, a secret court system which presiding clerk magistrates. I don't know. I think that there are things that just kind of come to mind that might be taken out of context here for what these might mean. But I've never heard of a secret court system for the politically connected, and I'd be very surprised if Massachusetts has one.
Yeah, I mean, the court proceeding is supposed to be open to the public. Biano says, "Hi, brothers. Are these questions good for Karen?" Well, I think we went over them. I think these questions are. If you look at the question alone about the clips, it doesn't look good. But the other two questions, when they're, and I guess you can argue that the 12:45 or 5 a.m., they just want to know, for OWI maybe also for the other purposes of charge 2. But that last question is gold. I mean, that should be music to your ears.
The last question is the one that I think really gives it away. And again, of course, you never know. Maybe they'll go back and think things over and change their minds and find her guilty of everything. It's possible. But I think based on that last question, that's pretty unlikely.
Here's a comment from Levin T. Proctor's wife called her a murderer once. One.
Okay, well, that's slander.
Again, if that's true, if that comment is true, we don't know. Christine
that's why I said that's potentially slander, right? I threw in the word potentially.
Yeah.
Lawyers love using lawyer words.
Christine Relander, I have rewatched the charge conference numerous times, and it looks like Yannetti asks for an OUI instruction. Is that the same as making the charge?
I think what you're asking, Christine, is that the same as being charged with it? And the answer is, since it's a lesser included, they go hand in hand. Anytime you're being charged with a crime, if there's a lesser included, either side is allowed to ask the judge to read an instruction for that lesser included. Lesser included of manslaughter being caused by drunk driving is obviously drunk driving. So just like if she wouldn't have a license, they could technically say driving without a license as a lesser included.
Mm-hmm. Newman's mom gives a super sticker for bringing order to this chaos. That's what we do here. We bring calm and order to the chaos. That's what we do here, Brother Counsel Studios. Verdict statutes by VS. Do you remember your questions on Sunday on violative verdict slips? I sent you an email. That's what I was asking at. Your thoughts about that. Violative verdict slips. Ooh, I'm sorry. I got a lot of emails. I'm not sure specifically. Let me take a look because you just sent this in now. And we have to wait anyway. We're still waiting for Judge Canoni to come back. And in case you guys missed the fan, we can always get that going right there.
I don't remember seeing an email about that. I'm assuming she's talking to you.
Yeah, I think she sent it to me. Verdict statutes. I'm trying to find it. I'm not sure what it means. Violative verdict slips.
From a general, as a general matter, what that means is it's a verdict slip that violates some form of either due process or criminal procedure or the court rules or something along those lines. And if it's violative, then in and of itself, it's not.
Oh, here we go. I see.
It would be like a verdict slip that doesn't have a not guilty line, for example, or doesn't have a line for the foreperson to sign.
Here, I'll pull it up right now.
Okay, let's see.
I will pull it up right there, right now. Give me a second. Got to download it. And anyway, we're still waiting for the judge to come back. Okay, let's share this with everybody. We'll remove that court feed for us for a moment. And don't worry, I'm keeping track of it. As soon as it goes live, we will go live. Violative, here it is. So this is part of the email that I got. Just pulled it up. I hope you can all see it. If not, I'll try to make it bigger. How about if we bold it? Maybe that'll make it easier. I don't love this font either. Times Newman Roman. Here we go. Commonwealth versus McLeod. Issue. In this case, the jury verdict form allowed for a finding of guilty, but did not provide a clear method for the jury to indicate a not guilty verdict. Lack of clear options raised concerns about the potential for jury confusion. Holding. The Massachusetts Supreme Judicial Court recognized that having a verdict form that does not allow the jury to express a not guilty finding could undermine the defendant's rights and for the integrity of the trial process. So it seems like these are a number of
cases. Due process. Yeah.
So,
I mean,
like, these
without
are all
having a not
like-
guilty line. If you don't have a not guilty line, that's violative of due process, just on its face. You can't have a verdict form that doesn't allow a jury to say not guilty.
Right. So, I mean, and here the question is again, under the. Oh, okay, she's coming back. So let's. Let me get her back. I hear she's coming back.
Cute.
Okay, so we'll go back to
Sorry.
our
need
discussion
to
after we're done here. Want to get that checked out, Salman?
Which one?
That cough.
Oh. I'll survive.
I think somebody said that they caught Hank Brennan on a hot mic saying, "I can't do this again."
I heard that also. Who knows?
All right, the court, please. Jurors entering.
Jurors like sent that question out like an hour and a half ago. Like, sheesh, that's the last time we're sending out a question.
Court's back in session. You may be seated.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements and the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor, and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor, and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor, and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully?
Hey,
All right, so with that, I am
Can I ask
going
that
to
question?
send you back out.
Before the jurors are set, can you receive-
Sure, why don't you come on over?
I'm not sure what that question was to the jury. Does that make it any clearer?
Yeah.
Waiting
What
for,
if they say no? Then what?
Right. You're supposed to write a letter now. Say,
Right.
no, Your Honor, it's not making it any clearer.
She explained it. I just still think that the verdict form is really unnecessarily complicated. It's the way it is.
I heard myself say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said, then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All right, to the court, please. Jurors, follow me.
Yeah, I'll read you a tweet that Larry Foreman, the DUI guy plus, just said. He said, "This is all but over, folks. Karen is seen crying in the courtroom. David Yannetti is smiling at the family. The family is happy as they speak to David. We finally have a resolution. Verdict will come very soon, definitely today." It's hard to disagree with Larry based on what we've seen.
Yeah.
It seems like we're going to get a verdict.
Are you satisfied, Mr. Yannetti?
Yes, Your Honor.
Okay. I'm going to ask everybody to stay a few minutes. I'll be back
Yeah.
out in about 5 minutes.
Yeah, I should tell them to stay.
Questions and thoughts.
Yeah, just stay a couple minutes because, we might have a verdict in a few minutes.
Yeah, it certainly seems at this point. I mean, look, you never know what's going on in the jury room. I don't know if I've said that before. There might still be one holdout who's still saying, no, she's guilty of murder. It's possible. It might be they're all saying she's guilty of murder. Who knows? We don't know what they're saying in the jury room. But based on everything that's been presented and argued, it certainly seems like the jury is leaning very strongly towards guilty of drunk driving and not guilty of everything else. And certainly seems like there's good basis for that to be the verdict.
Yeah, that would be, like a big win. Tia Walker says, "Hi, brothers. As an Irish person, it's Sue the Bejesus. Bejesus, not Bejesus." Okay, Solomon. So get your lingo right. Bejesus.
Got it.
Creed. She did documentaries. Grand jury true billed. A grand jury true billed.
So I think what that's going back to is our conversation about the defamation. And if you say that she was indicted or that she was true billed, that would not be defamation. If you say that she is a murderer, that is. You got to be careful with your words. You got to be careful. It's really simple. Don't go around calling somebody a murderer. How about that?
Just say alleged.
Say alleged. If she's convicted, you can say whatever you want. But when somebody's charged and going through the court system, don't go around calling that person a murderer. Simple as that.
SM, for OUI to be lesser of manslaughter, shouldn't it be specific to 12:45 a.m.? The OUI is not a standalone one.
Oh, that's a really good point. That's a really, really good point. Okay, to make sure everybody understands that question, what SM is saying is the manslaughter did not take place, the alleged manslaughter did not take place at 5 o'clock or 6 o'clock in the morning. It only possibly could have taken place at around 12:30, 12:45 in the morning. That being the case, the lesser included of that charge of manslaughter, while OWI or OUI is driving at that time, not 5 hours later. It's a very, very good point. Sometimes it's hard to put a finger on why you disagree with something, but this is one of those cases where I disagree with what SM is saying. And I think that it is appropriate based on the evidence that was presented to give the lesser included to any time, no matter when it was. That's a good point, though.
Yeah, that's a great point. I like that thinking. That's really great. That's some great analytical thinking there. Go to law school. All right, Quinta G. I could never be a litigator. How do you guys do it? LOL, my anxiety level watching some of these trials is in outer space like Karen's Lexus. I like practicing boring corporate law. Well, I'm telling you, I mean, there is no calm moment when you're waiting for a verdict.
I remember there's a story that my dad
Hold on
tells
one
us.
second. Hold on. They did not get to the audio fast enough there. Oh, she said we need to go to sidebar. Maybe they
There
got
can't
another
be a
letter,
verdict already.
another note.
The letter may very well say we have a verdict.
But it was not my fault, okay? They didn't go fast enough to audio to hear that. But she just called for a sidebar. So maybe there's a verdict now.
Just to address what Quinta Gee was just saying, I remember my dad told us when we first started practicing law that a judge told him while he was pacing up and down and losing his mind in the courthouse waiting for the jury to come back. And mind you, this is 40 years ago, 50 years ago, before you could just be busy on your cell phone, playing chess or something, and checking emails and checking Twitter. And the judge came over to him and said, "You've got to be able to relax, otherwise you're going to lose your mind." So yeah, it's always tense waiting for a verdict, but it's something that, as you do it a few times, it gets easier. As a lawyer, I'm sure as a litigant, it doesn't get any easier.
I remember the first case that I tried by myself, just completely by myself, without you, without my father, without anybody there in the courtroom besides myself. And it was a small little case. And I worked my brains off to win that case. And I was pacing. I couldn't calm down at all. I ended up winning, but it was just crazy. It's just nuts.
Yeah. Oh, yeah.
Frank Philippis. What'd you say?
Waiting for verdicts is definitely one of the harder things to do.
Yeah. Frank Philippis, $4.99. Thank you very much for that. Okay, well, let's see what we have here. And that would be pretty quick if they just, okay, guys, we know what to do. Sign it. Send it back. We have a verdict. Let's get out of here before lunch.
I think this is going to be one of the situations where the jury just disappears. There might be one or two that that talk, but I could only imagine that with the circus surrounding this case, they're going to want to disappear and get out of here.
Here's a question, Solomon. Do you think that if it comes down as guilty for OWI, that the prosecution moves to have her taken into custody?
No, I don't think so. I think that she was facing a murder charge, facing life potentially in prison, and she's not in custody. I can't imagine that for a drunk driving conviction she'll be in custody. Typically, for a felonious assaultive charge or a murder charge, somebody will end up get taken into custody because they're considered a danger. But no, I'd be very, very surprised, even with this judge.
Yeah. All right. Well, I don't know what they're talking about there, but
it'd be interesting. I guess it's not a verdict. Maybe it's another question.
Look, nothing's typical in this case. So who knows?
Nothing is typical in this case, that's for sure.
To Truth for Liberty, for concluding a lesser, doesn't the charging documents have to provide time frame along with OUI?
It has to provide enough of a time frame to give the defendant notice of what he or she is being charged with. That's certainly an interesting. It's funny. The more I think about this, the more I think this could be problematic. Saying, well, it's either drunk driving at 12 o'clock or at 5 o'clock. But the defense already didn't object to that as an instruction. I think the defense is thrilled that this is what the jury is hung up on. So I think in their minds, they're just saying, yeah, sure, great. Get this conviction for drunk driving. Let's get out of here. Because then, she beat the case. She beat the charge. There's no way of looking. If all she is convicted of is drunk driving, this is a tremendous win for the defense.
Yeah.
And frankly, for justice.
All right. Karen Reed, here's from $10 from Latinagra, whatever. Karen Reed acquitted of all charges. Verdict is in at 2:27 p.m. Well, they may come before that. They come at 12:27 p.m. But it looks like they're going to convict her on OWI, though. I mean, that's how it looks like they're leaning. So we play the waiting game.
Larry Forbin just had another funny tweet. This is the most this is the most expensive OUI case I have ever seen in my career. If that's all this ends up being.
All right, so we'll see everybody at 1:30.
Oh, okay. Well, I guess that was not a note with the verdict. So they're taking a break till 1:30.
Does that mean that the jury is also leaving? No, no way.
No, I mean, they're probably having
To the
lunch.
jury. Okay.
But they probably told the jury that we're not going to take a verdict during the lunch hour. So if you have a
I
verdict,
doubt it. I doubt they told the jury that. I think if the jury comes back with a verdict, they're going to call everybody back.
well,
I
they
don't
just
think
said we'll see you all back at 1:30.
Was the jury in the room when they said that?
No.
Okay, so the jury probably doesn't know that.
Oh, okay. Well, we'll
I
see.
mean, I would think at this point it's typically once the jury gets the case, they're in charge. If they say we have a verdict, then they get that verdict read as quickly as possible, generally speaking. So even if it's during the lunch break, I would imagine that they would call everybody back and say, "Come back, we've got a verdict."
All right. Well, we'll
we're going
see.
to have a verdict pretty quickly, so I guess we'll go back on when the verdict comes in.
Yeah. Okay. So let's take a little lunch break, I guess, ourselves. But we'll keep the chat open. We'll keep the stream going because something tells me we may have a verdict by the end of the day today. So, Salman, thanks for jumping on with us. Hopefully, you'll come join us back when there's a verdict. And that's going to be it. So, guys, enjoy your lunch. And we will see you back here, hopefully by 1:30. Here's you can have our friends over at NBC Boston. We'll leave it in their good hands there. And I'm sure they have no problem with us playing it on our stream. So we'll be back with you. If there's a verdict, we'll get back to you as soon as possible. If not, then we'll see you around 1:30.
And if it comes down.
And Melody, we look forward to hearing back from you about how people outside are reacting to these moments, such as hearing questions came in, what those questions were, because we know more people are gathering.
Yeah.
And so, but right now, let's go back to our legal expert, Michael Coyne, as we wrap things up. And of course, we're going to come back to you again, Michael. Is there anything else you wanted to add now that the jury is back in the deliberation room?
No, the only thing that's surprising is these questions about the jury verdict form weren't resolved before the jury ever went out in the first place. You would have thought they would have proposed and debated a new revised jury verdict form before the jury instructions were given so that we don't have these issues, because already over a couple of the days we've debated them. And it does appear that a simplified form will aid the jury's resolution of the event.
When we talk to you later, Kent Confidential, and get more specific, let's talk about what this might mean for future jury slips. But right now, let's just focus on what we have in front of us.
Michael, thank you very much. All right, it's 12:30 now. We'll give you one more live picture outside the Norfolk Superior Courthouse, where people have gathered, mostly, it seems, in support of Karen Reed. You can see her supporters holding up the sign language sign for love. They've been encouraged to be quiet while the jury is deliberating so that they don't interrupt that process.
There you see it.
Yeah,
I got to say, they're quiet. That's a large group. And
absolutely. And this is a far cry from what we saw 1 year ago, of course. And now that trial watchers will know these questions have been asked by the jury, we should expect that more people will show up in anticipation of a jury verdict coming very soon. We appreciate you joining us today for this breaking news coverage of the Karen Reed murder retrial. We had 3 questions from the jury. It sparked a lot of discussion.
yes, and we're following it. You don't have to go anywhere. As soon as anyone is back in the courtroom, whether it's questions, a verdict, we will have that for you live right here on NBC 10 Boston, and always NBC10Boston.com.
He said the gator was a pet, and its owners say it was on its way to a zoo. Real casual.
Wow, real
in there.
casual. Wow.
I'm glad I wasn't a
rolling into
guest
the
there.
boba tea shop there. All right. Listen, today a federal appeals court is holding a hearing to determine whether the National Guard troops that were deployed to Los Angeles
Please be seated. Court is in session.
All right, so I'll see you at sidebar so we don't do this part in open court.
Oh, we don't do what part in open court? What part are you talking about?
Jim, can I have that question, please? Thank you.
Good question.
All right, so as counsel knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this and sending it back.
The defense position is not certainly not. I agree. We can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than 1 count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
But I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel?
Okay, so
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute. Thank you.
okay, so Solomon, the question was, if we have a verdict on 2 of the charges and we're hung on 1 of the charges, what are we supposed to do? Is that a hung jury for all the charges? This is exactly the situation that the first jury found themselves in. So, and by the way, I think that our scenario is playing itself out. They're hung on maybe DUI, and therefore they're hung on charge 2, but they have a verdict on charge 1 and charge 3.
So predictable. This is pathetic. This is not court. This is a circus. This is really pathetic.
So the jury just wants to know what can we do if we are hung on charge 2? Does that mean that we're hung on the entire verdict? And Judge Cannoni wants to answer, I can't answer that for you. And Alan Jackson said, well,
Why can't she just say, yes, you can give us a verdict on count 1?
Right, I don't know why. Why can't you say that?
Tweak with the court's language. I don't have a principal objection to the court's language that if we not answer the question at this time, I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict, and that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
Not consequence.
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the jurors'
Exactly.
verdicts.
It's not a
That would be punishment. Of course, you can't answer a question
Exactly.
like that. This is not the consequences of the verdict. It's
What he's
how
doing
the
now is making a very clear record for appeal.
So I think saying, I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly
Correct.
assuages our concerns and it protects Ms. Reed's rights. I think that.
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
Add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
It has nothing to do with consequences. They don't want to know how long she's going to sit in jail for. They just want to know, does that mean that we're hung on everything? Can we do a partial verdict? That's essentially what their question is.
I allow the court to finish writing, but at this point, that is over our objection.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights.
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't
is
tell
that.
you to ignore it, Your Honor.
All right, we are all set. So let's send this in, please.
All rise.
Terrible. Just terrible. Wow.
Yeah, I mean, they basically are just asking if there could be a partial verdict. That's a question of law, isn't it? If the court rules allow a partial verdict, then she should answer, yes, we can accept a verdict on charge 1 and charge 3, or whatever charges you have a verdict on. And if you're hung on that other charge, then you can be hung on that other charge. Isn't that a question of law?
I just really hope the jury sees through this. I really do. They're trying to do the right thing. They want to do the right thing. The problem is that they think that the judge is going to give them correct and appropriate answers, which is generally what you want juries to think. Unfortunately, in this case, that's a problem.
Yeah. Okay. Well, I mean, Alan Jackson was pretty clear about it. But okay, so I guess that's going to be it for now. We'll put the fan back up. And we'll wait for.
Isn't she going to read it to the jury now, or is she just going to write the answer and send it in?
I think she said they're just going to write it, send it back. I think that's what they said.
Wow.
That's what she said.
This is unreal. This is exactly what everybody thought was going to happen. Not guilty on everything except hung on drunk driving.
Yep. All right, Simon. We'll see you back here soon.
Goodbye.
All right, guys. We'll see you back here soon. We'll see when we get that verdict in.
Jurors are entering.
Whoa, look at that. What's going on?
Court is back in session and be seated.
All right, jurors, I know you want to go home, so it's been a long day for everybody. I have to give you those same cautions. Please do not discuss this case with anyone. Do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be careful with your social media use. We know you've all been working really hard and we appreciate it. So please just clear your heads. Don't think about this case at all as best you can. And we'll see you tomorrow morning when everybody's fresh to start again. Thank you.
All rise for the court, please. Jurors following.
You know, this could be that there's just like one holdout, and that's why they're not just saying that they're hung.
Jury's exited the courtroom.
Okay, Tori. All right, we'll see everybody tomorrow.
Thank you. Court is adjourned.
All right, well, a little surprising, I think. I think we were all kind of expecting a verdict today, especially after those notes. Gotta fix my tie here. What's going on? So a little surprising there, I think. And, you know, it could be, and again, of course, this is all just rank speculation, but it could be that there's maybe, you know, one or two holdouts, and they're thinking, you know, maybe if we deliberate more, then we'll get those other one or two on our side, and maybe, you know, a quitter of everything. So who knows? We don't know, but that could be. I mean, otherwise you would think at this point they would say, okay, we're hung. And we just can't agree. But there's something that's pushing the conversation to continue, obviously. And again, you know, this is just a reading the tea leaves or reading the in between the notes that seems like most of them already want to quit her on 1 and 3, and they're struggling with 2, struggling with DUI. Apparently, that's what I would think. And maybe it's, you know, maybe the DUI is, most people think that she's guilty of DUI, and maybe there's only a few holdouts against the DUI. Now, quite frankly, I think it would actually benefit Karen Read more if they find her guilty on DUI, just plain DUI. Because if they hang on DUI, that means they're hanging on the entire charge 2, which means that the Commonwealth can try her again on just charge 2, which would include involuntary manslaughter as a result of OWI. But if they find her guilty, I think you have to realize this, you know, for the people that are on Karen Read's side, if the jurors are on Karen Read's sides, then, and that's why they're saying, no, we're not going to find her guilty on anything. Most people and some other jurors want to find her guilty on DUI. Well, it would actually benefit her. It would benefit her more for you not to hold out and say, we're going to hang on charge 2. Because if you only hang on DUI, then that's considered hanging on the entire charge 2, which means that they can try her again on the entire charge 2. So just find her guilty of DUI. Like that would really be the biggest benefit for Karen Read right now. All the people that are in that jury room that are on her side, just find her guilty of DUI, and that's it. And that's the extent of her guilt, and therefore, you know, should get probation, and that's it. If you hang on it, then you're going to be hanging on the entire charge. So that could be what's going on in the jury room. I mean, it could be they're just trying to figure out what's going on with the count too. Because it seems pretty clear to us from the notes that they are acquitting her on charge 1 and charge 3. But we all just want some finality here, unfortunately. So, okay, well, I guess we will be back. I guess we will be back tomorrow because there's got to be a verdict coming tomorrow at least. You would think there's a verdict coming tomorrow, or maybe they're just going to say that they're hung. So, yeah, but this is part of the problem where people, if they're convinced, which is why this verdict slip makes it a little complicated. Because if you're in the jury room and you're convinced that she's innocent of DUI also, and you're going to fight that, it's really going to turn out to hurt her, and people may not realize it. So yeah, okay. So we'll have to come back tomorrow. We'll put the stream up for tomorrow, and we'll see what tomorrow brings. You know, the first day I didn't even think anything was going to happen, which is why I didn't even bother streaming just a verdict watch for us to just sit in the chat all day. But you know, some people like to do that anyway. I definitely can't talk for 7 hours straight. Not yet. But tomorrow there's got to be a verdict tomorrow. There's got to be a verdict tomorrow. So, okay. Anyway, we'll be back tomorrow. No recap today. No reaction today for reaction videos. So we're just going to have to keep waiting. But again, I would tell all of you people out there, all of you that are supporters of Karen Read, and again, I believe that the verdict should be not guilty, that not to worry, because most of the time the jury gets it right. And I think it's going to be difficult to swallow that 12 jurors are all not going to realize that there's reasonable doubt. So I think you should all sleep well tonight. All right. So we'll see you all tomorrow. We'll do the stream for tomorrow. We'll have it up. And that'll be it. All right. Have a great night, everybody. Thanks for joining us, especially was on such last minute notice.